Senator Lyons.
Thank you, Mr Deputy President. Along with Senator McDonald, I was a Labor's senator, one of Labor's senators on this inquiry, and I have to say it was a really interesting morning that we spent hearing evidence from a range of law agencies, the Department, the Law Council of Australia and so on, who expressed their concerns about some aspects of this bill. And I would have to say that the majority report and Labor's dissenting report covered off on similar concerns. In our view, the majority report didn't go far enough because it felt that a number of the issues raised around privacy, around collection, could be dealt with in the explanatory memorandum, but Labor felt that really, if we wanted parliamentary oversight and proper scrutiny, that the concerns needed to be dealt with through a range of amendments, and Labor has a range of amendments before the Senate, and I note today that the government has indeed put some amendments forward as well. So I agree with Senator McDonald that it is good to see when a Senate committee makes strong recommendations through a majority report and Labor's dissenting report, that some of the issues raised are taken on board by the government. So that is a good step. However, the government has stated that biometric checks at Australia's air and seaports will enable rapid identity verification with domestic and internal security, law enforcement and immigration agencies through portable handheld devices and other sorts of biometric testing. And certainly Labor, along with the government, supports the need for Australia to be able to ensure that people coming into our country and our citizens leaving are who they say they are, and that we do the utmost to ensure safety at our entry and exit points in this country. And as other senators have said, this bill really does try and collate a number of tests that are already available under the law, but unfortunately it does go further than that in putting all of those issues together, all of those tests together. And certainly Labor sees the need that we balance the need for good security with privacy and other issues. And I think in that context, the bill as it currently sits before us, and even with the government's amendments, doesn't quite get that mix right, and maybe there will be some opportunity in the committee stages to further talk about that and flesh that out. The significant issues with this bill, to me, just demonstrates, unfortunately, it's another example of poor drafting and execution by the Abbott government. We often see bills coming before this place which are poorly drafted, and I think this bill suffers from that. The government will argue, I'm sure, that not much is changed with this bill, and whilst it's true to an extent, there aren't wholesale changes being made to the bill, nor are there wholesale changes being made to current practice. Nevertheless, the changes that are being made are quite significant, and that was borne out in our dissenting report and indeed the majority government report. So Australians ought to be concerned about these changes, particularly when the bill lacks genuine independent oversight and there's no parliamentary oversight. In our dissenting report on this bill, Labor called for a thorough review by the Privacy Commissioner, and as Senator McDonald has just outlined, the majority report, supported by government senators, also called for the Privacy Commissioner to undertake a thorough review prior to the passage of the bill. Now, both of us called for the privacy impact statement to be publicly released. Now, to put it on a website, you might argue is publicly releasing it, but not to draw it to the attention of members of the committee is a failure by government and the department. Given that privacy was a major issue, I think the department had an obligation to draw it to the committee's attention through the Secretariat that the privacy statement was indeed on the website. To do less than that, I think, just continues to create the suspicion that we already have around this bill. And of course, Labor wasn't alone in calling for the Privacy Commissioner to look at this bill. A number of submitters to the inquiry shared this concern, and it is a very valid concern of balancing the issues of privacy with securing our borders. We all understand that, but the bill doesn't seem to cover off enough on the privacy issues. The Law Council of Australia made a very strong submission and some fine recommendations about how we really do cover off on the security issues. But of course, making that statement publicly available, drawing it to the attention of the committee, simply hasn't happened, and that just makes people suspicious. Labor also felt that the current obligations to store biometric data needed to be tested from the perspective of the Privacy Act. There are very real concerns about the retention of and arbitrary collection of biometric information, concern about the collection of data, its use, who gets access and its retention. None of these concerns have been addressed by the government. During the hearing, I raised the issue of a child subject to a custody order. It could be that biometric data is taken from the child for the purposes of identification in relation to the order. Although the department used the example of fingerprint data, I'm not sure how you would have access in some recorded way to the fingerprints of an 8-year-old who's subject of a custody order. How could you have that, and how could you check that using a fingerprint scanner? Now, despite putting that question directly to the government, they've simply been unable to answer that, because we know for a fact very few children, I don't know any, who are subject to custody orders have their fingerprints taken. So I really, that question still remains unanswered. Now, we go on with that one there, because we did ask the department and the government a lot of questions about that. So if this biometric data is taken from a child who's subject to a custody order, the department was unable to say how the data would be stored and for how long. Now, that's a fundamental question, and it's one that all Australians should be concerned about. Yes, of course, we don't want children either trafficked in or trafficked out of Australia, and we don't want children who are the subject of custody orders who don't have permission from parents to leave the country. Of course we want that picked up at the border. But nevertheless, we can't overshadow that by saying, well, we'll collect this biometric information and it will be stored, and for the department to not be able to tell us how long it would be stored for, if in fact it would be stored, and what would happen to that information. I went on then to pose the question to the government through the department. So you've taken biometric data from a child who's the subject of a custody order. What happens when the custody order no longer applies? And again, the government was simply not able to answer that question. Now, that could mean for that child who maybe had a custody order applying to them from a very young age, who's unaware that there's a custody order, who doesn't remember being taken to an airport and biometric information being taken, but every time as an adult they come into the country or leave the country, is it flagged up? And again, I asked the department, and I got conflicting answers. If you have a look at the Hansard record of the inquiry, we got conflicting answers from the department, and some kind of blurry excuse or reason given that this would all be dealt with in policy. But I think Australians have an absolute right to know this about storage of information, particularly in relation to custody orders, and particularly when those custody orders no longer have any bearing. What happens to that information? And to date, the government has simply not been able to give us answers to those very real questions, and that's a really strong example of where the need to protect children butts up against this issue of privacy and retention. And in fact, the Law Council gave very good evidence of it's one matter, if you like, to collect biometric information. It's quite another then to store and to keep and to log to make sure that that information is secure. Again, we weren't given, in my view, any real answers to that, and despite meetings since with the department through our shadows, my understanding is that they haven't been given answers to those questions either. So the question of that child as an adult, what happens to the biometric information, and what is flagged up every time they enter or exit the country. And of course, the Scrutiny of Bills Committee also raised concerns about the collection of personal identifiers, and that the collection of data by means other than the fingerprint scanner would not have parliamentary scrutiny or oversight. The committee questioned the claim, and I quote, "The statement of compatibility that the measure is compatible with the right of privacy. However, the committee makes the point that the right to privacy needs to be understood in the context that the power authorises methods of collection which are not limited to that which is explained and justified in the explanatory memorandum." The Scrutiny of Bills Committee stated that the parliamentary oversight could be achieved through the use of a targeted amendment which included appropriate safeguards, and I think that advice from the Scrutiny of Bills Committee is a good one, and I would urge the government to take that on board and perhaps look at an amendment around or in the terms that's been suggested there. Again, that similar view was expressed by the Law Council of Australia, but unfortunately, to date, we haven't seen any amendment from the government which would allay any of those very real concerns. The other concern, and this was raised again by Senator McDonald, but again our response to the solution to our concerns is different, but it's in relation to children and vulnerable groups, so young children and people who have some sort of disability which makes it impossible for them to either fully understand what's happening to them or to ask the appropriate questions. The bill proposes that data can be taken from children and vulnerable groups. Now, the departure here is that into the future it can be taken without the consent of the parents or the guardians. And of course, I can understand there will be occasions, hopefully not many, but there will be occasions when we do have to take data without the consent of parents or guardians. I absolutely understand that, and if I was particularly had a child that was subject to a custody order, I would want that to be a feature of our system. But again, how children would be protected, how the dignity and the rights of children in vulnerable groups were to be protected was all left to policy. And I don't think, and others at the inquiry also agreed, that that is strong enough. It is important that on these matters we have parliamentary oversight where we can really see what is happening, where we're taking hopefully just a few children without the consent of their parents. Now, it would be easily dealt with if an independent person was in the room who could act in the interests of that child or that vulnerable person. Now, when I questioned the department about that during the inquiry, they gave the example of the fingerprint scanner and said, well, we'll be probably using the scanner. Now, again, I would question, if you're using the scanner for children, where's the data coming from that it's being compared with? Or is that the first collection point? Because presumably we don't have the fingerprints of the children that we're seeking to protect, certainly not in anything that I'm aware of? Or is this an exercise where we are using the scanner to pick up fingerprints in the first instance and use that as the first comparator, but the department is telling us that that fingerprint data won't be retained? So again, it is not clear. And in terms of why they felt you didn't need the independent oversight from a guardian or some other person was because, well, we'll be using the fingerprint scanner out in the public arena. And again, that's what they said on the Hansard. And that doesn't make anything safe. We have people mugged in the public arena. We have people murdered in the public arena. Just because something is done in the public arena doesn't mean that that child is safe. Most people going through our immigration are focused on getting through customs and immigration. They're not watching, most of us are not watching what's happening to others, and even if we are, it is unlikely that we're going to put our hand up and say, excuse me, just what are you doing over there? So that suggestion that the way we protect children and vulnerable people is, well, this will all be done out in the public arena, quite frankly, is a nonsense. And I don't believe, in terms of the government's amendment that I've seen today, I don't think that that actually meets the description of that amendment, because if I'm going through customs and immigration and I see a person having their fingerprints taken, I'd immediately think, wow, what have they done wrong, or what's happening here? So I think if we're going to do it with dignity, it has to be done away from the public arena. But it should nevertheless always be done in the case of children and vulnerable people with an independent advocate there. It's not a hard ask to have an independent person there. If we're serious about protecting the rights of children, all of their rights to safety, their rights to be safe, their rights for custody orders to apply, then putting that independent guardian in place where we're taking that child's data without consent seems to me to be a small price to pay, given that we hope it is not going to be very many children taken in this way, or indeed vulnerable adults. So I would urge the government again to look at that and to put that independent oversight in. I don't, as I say, I don't think it is too high a price to pay to make sure that there is independent oversight, that that child is always treated with respect and is always safe, and that can only be provided when there's independent oversight. A policy cannot protect a child. Only an independent advocate can do that. It is not fair to put the onus of protecting that child onto department officers who have a different job to do. Their job is to take the biometric information and to do that with respect and dignity. It is not their job to stand as the guardian for that child, and you cannot write the safety of the child or the vulnerable adult into a policy document. So the government's amendment, which notes that data won't be collected in a cruel, inhumane or degrading way, is a step forward, but I think it needs a little bit of flesh on the bones. Just what does that mean? And I would hope that the government in the committee stages talks about what they mean by that, because again, what's written in a policy and then what the process is for carrying that out are two completely different matters. They're not related at all. A policy could say X, Y and Z, and there's probably already a significant number of policies in that regard, and we want to see actions, and we want to see children and vulnerable adults protected. So Labor has 3 amendments in regards to this bill. They go to the storage of data, they go to the vulnerability of children and adults, and they go to the very important issue of privacy. And I would urge the government to look at them seriously. We do support the need for good security at our borders. We do support the protection of citizens and non-citizens, but this bill, the wide powers, just go too far, and Labor has got very sensible amendments there that we would urge the government to look at seriously and we can get on and support this bill. Thank you, Mr Deputy President.
Thank you. Senator Bernardi.